investment arbitration. You weren't expecting Scott Weiler as your moderator, and you're rightly disappointed to see me. Unfortunately, Todd had a family emergency and is not able to join us. And we wish Todd all the best. I'm truly a poor substitute for Todd, because unlike him, I'm not an expert in international investment arbitration at all. I'm a bit like Andreas, and he probably will not mind me saying this, but we're both here to learn. Andreas is a senior lawyer at the Italian Body Secretariat. We worked together very well for many, many years. Right, we have, and I know this is being said about any panel that you have attended. We have a fantastic panel, both in the room and online. And let me say how we're going to approach this. Each of the panelists will give a short presentation of their paper or draft paper, or of their views on the topic that they will address for about 8 minutes max. And after the presentations, I may have, and I'm actually breaking the agreement that we had, I may have some questions to each of them. And I will also invite the panelists to react to each other's presentation. And after that, I will give the audience an opportunity to ask questions or make comments. Now, on this panel, we have, and we'll first hear from Sotirios Lekas. I'm probably mispronouncing that terribly. Okay, well, lucky me. He's a postdoctoral researcher at Groningen University. I used to be not close, but coming from Maastricht University, I was not too far from Groningen University. And he will start off and talk about general rules on compensation in international investment arbitration. Next, we will hear from our participant online, which is Wojciech Gimza. And again, I'm probably not pronouncing that well, but I'm doing my best.
Very good.
Thank you. I'm doing well today. Not always the case with foreign names. He's a researcher at the European University Institute, Florence, which is my alma mater. He's a lucky guy. And he will talk about references in the case law of the International Court of Justice in international investment arbitration. Then we have Federico Ortino, professor at King's College, London, who will talk about legitimate expectations in investment treaty arbitration. And as a fourth speaker, we have Jonas Honovar, senior research fellow at the Max Planck Institute in Luxembourg. He will talk about how investment arbitration has become a battleground. I like your title. Has become a battleground for interstate conflicts. And you'll look in particular into the Ukraine war situation. And then finally, and we owe a special thanks to our last speaker, Caroline Henkels. Caroline is an associate professor at Monash University, and she will be talking about exceptions in investment treaties, and I'm sure that she will talk about how these exceptions are used in international arbitration, investment arbitration. Now, why do I say we owe a special thanks to her? Because She was contacted late last night with a request to sit on this panel, and we're very happy that you agreed to it. Right, so I would say without further ado, we will turn to you, Sotaric.
Great. Thanks very much, Peter, for the kind introduction and for inviting me, and to the organizing committee, of course. I also have to acknowledge the ERC's funding in terms of this research. That's why I'm here, otherwise I would be online as well. Third preliminary point, my discussion is going to be about rules of interpretation. Now, if you want to ask questions about compensation, that's fine. The answers might be somewhat unsatisfactory. So, as I said, this research forms part of an ERC project. The paper I'm going to present today forms part of a broader project on the content and evolution of rules of interpretation in international law more generally. It compares and contrasts rules of interpretation across different subject matters, trade, investment, human rights, across different sources, treaties, custom, unilateral acts, and tracks its evolution through time. Now, the other preliminary point is what I mean by rules of interpretation. It is the rules which set out the process by which the content of an existing rule of international law is determined. Articles 31 to 33 of the Vienna Convention is the example. These are distinguished from rules relating to identification of normative propositions as rules of international law. The example is what the ILC is doing with respect to custom or general principles. The point here is that identification and interpretation are two distinct juridical operations. The present paper discusses the practice of investment tribunals in making use of these rules of interpretation. How do they do so? Most investment tribunals are called upon to apply and interpret the treaty, an international investment treaty, a bilateral investment treaty, or well, the ECT, for example, the Energy Charter Treaty. Less conspicuously, sometimes investment tribunals might be called upon to determine whether a unilateral act of a state creates binding obligations under international law for the declaring state. There are less cases with respect to that. They relate to domestic provisions of foreign investment laws, whether they bind the state on the international plane. And the third way they do that is they are called upon to apply rules of custom or general principles of law. The most notable example is the rules of state responsibility, compensation, essentially attribution of conduct, and so on and so forth. Now, I will try to be brief. I won't dwell too much on treaty interpretation. In terms of treaty interpretation, most tribunals now use the VCLT rules, and I think it was Martin Paparinsky who said that this is the only game in town. How well they do so, it is a matter of discussion. But the key takeaway is that they do so, and most of the reasoning is structured around these rules. And also these rules are the means for critique and sometimes review of those decisions. Okay. A much less examined issue is the one on unilateral acts. The issue, as I said, has arisen with respect to domestic provisions relating to under domestic investment laws. Now, there is a tendency for tribunals to parallel domestic provisions which encompass consent to international arbitration with optional declarations under the Article 36.2 of the ICJ statute. So by drawing this parallel, they immediately say that they're binding to the state on the international plane, and they proceed to interpret them as if they were practically a treaty. They apply the same rules, text, context, object, and purpose, and so on and so forth, good faith. In my view, this is problematic because essentially the process of identifying whether a unilateral act is binding on the international plane the process of interpreting it, if you have already determined that it's binding, are distinct. Because the process of identification also has a presumption against bindingness. And domestic law applies equally to domestic actors and foreign actors. It's not necessarily meant to bind the state on the international plane. However, with respect to certain domestic provisions relating to investment arbitration, you can argue so, especially when they are pretty much not ambivalent. But yes, and the process of interpretation of a unilateral act whose status is undisputed, yes, it is true that it is much akin to treaty interpretation. How am I going this time?
You have 3 minutes left.
Okay, perfect. Now
2 minutes now.
2 minutes. The third issue is the interpretation of unwritten international law. Now, the point I want to make is there are tens, if not hundreds, of cases which deal with the application and interpretation of rules of state responsibility, which are formally unwritten rules. Okay, how they do so, most of the investment tribunals. First, they determine that a provision in the Articles of State Responsibility reflects, codifies, what you name it, a rule of a customary rule or a general principle of law. Implicit in that, this finding is an inductive examination of evidence. You know, this state did this, said that, and so on and so forth. But this is only a starting point. What they do after this determination is they use means akin to treaty interpretation. They go to the text. They take Article 8 of the ILC articles and they ask, what does control mean? What does instruction mean? Okay. What they also do is they look at the object and purpose of a treaty provision, as if it was a treaty provision. And also they look at the broader or immediate context of that provision in the ILC article. So they say that, for instance, the stability of international obligation entails a restrictive approach as to the customary defense of necessity. Or more technically, they say that because the provision of Article 38 on interest is amongst the rules relating to full reparation, we need to award compound interest instead of simple interest. So to conclude, as a general tendency, yes, the VCLT rules are the only game in town, but they are not only prevalent in treaty interpretation. There is a spillover to the interpretation of rules stemming from other sources.
Thank you very much. This morning and in previous days, we had occasion to discuss the prices of WTO dispute settlement. Now, the investor-state dispute settlement system has been criticized for a much longer time than the WTO dispute settlement system. The WTO dispute settlement system was still the jewel in the crown when there was already a lot of criticism in the direction of investor-state dispute settlement. Now, listening to you, how do your arguments feed into that broader debate of the legitimacy of investor-state dispute settlement?
Thank you very much. So yes, the main idea is what? Rules of interpretation as general rules on the determination of rules of international law instill some kind of predictability to judicial findings. So, and they provide a standard for assessment and critique. In the context of investment arbitration, for instance, the question is whether and to what extent these rules can be used also as a benchmark for annulment review, which is very much contested. As we know, annulment committees tend to have certain deference with respect to findings of panels, but there were committees like the Lucchetti Committee, which hinted that, you know, if the panel completely disregards rules on treaty interpretation, then this finding is reviewable either as disregarding of applicable law or lack of reason. And this also there is a spillover there. For example, the Enron Committee did the same with respect to customary international law. So with respect to necessity, they said, okay, many notions with respect to the customary defense of necessity are open to interpretation, but the court did not. They merely asserted that this is the defense of necessity.
Thank you very much. I think it's now time to turn to our panelist online. Wojciech, can I ask the organizers to dim the light so that we actually get to see Wojciech and hopefully also the background? And that is not Florence. Okay.
Yes, it's not
Yes.
Florence. And anyway, just you have to look at my face that much. I have a PowerPoint also to give you some numbers and a general picture of my presentation. So good afternoon, everyone, and greetings from Florence, Italy. In my virtual background is actually Polish-Czech border. My name is Wojciech Giemza, and I'm a PhD researcher at the European University Institute. Due to family reasons, just like Todd, I can participate only online, but I hope to engage with you and meet you all in the future. I present you a paper which concerns the references to the ICJ and the PCIJ investment arbitration. And by references, I mean not only jurisprudential borrowing, which some would call precedents, but basically anything ICJ, as I found that many mentions in investment arbitration context of the ICJ or PCIJ go beyond this, what we would call legal argument or precedent, though still having some argumentative function. The project is strongly empirical, both qualitative and quantitative, and I will focus on explaining the method and the data set and hope to discuss it further. In the paper, I use a case study which I carefully chosen for Todd, which is the PCIJ's Oscar Chin case, but hopefully it still will be useful. So without further ado, let's have a look. I suppose that many of you, when reading a decision of international courts or tribunals, have stumbled upon a reference to other case. Very often it's the decision of the same court, or it's the same tribunal, or the tribunal of the same field, especially in the case of investor-state arbitration. But very often when we talk about the external sources, so citing another body, the ICJ together with the PCIJ are by far the most popular sources of external citations, which also they have, at least on the superficial level, some kind of deference, as we see in the quotes from Azurix or from CME case. And on the right, you see a table by Damien Charlotin. He gave some quantitative overview of how much other bodies are cited in other fields. And as you see, highlighted yellow, ICJ, PCIJ are together by far the most popular. And the explanations for this may be seemingly straightforward. First of all, the structure of legal argument and use of authorities in adjudication in general, and ISDS in particular, is considered open and flexible. Second, the court, by its pedigree, its general scope of jurisdiction, and the position as a UN judicial body, has a specific status as an international court, which makes it a central, if not a supreme institution, if theoretically horizontal structure of international courts and tribunals. Third, investment law and arbitration are still considered to be in a developing stage, and their normative source base is considered to be scarce. That invites for jurisprudential borrowing, that is borrowing the norms from other fields, including the general public international law, in which inevitably investment law is embedded due to law of treaties, as Sotirios mentioned, through the law of responsibility, and so on. And the ICJ case law appears to be a useful transmission belt for these ideas. But fourth, the ICJ is not only present in the legal argumentation and not only for its jurisprudence in investor-state settlement references. Until recently, its sitting and former judges were involved to around 10% of investment disputes as decision makers and counsels. You see here on the screen the graph produced several years ago by the International Institute of Sustainable Development, which called out the moonlighting by ICJ judges. Now the practice has been curtailed officially by the ICJ. Not to mention that very often substantive public international issues are decided inevitably in ISDS disputes. For example, territorial sovereignty, as we see from the Crimean cases, on which Gunesh will develop upon. So we see that the ICJ statute, judges, practices, and the general legacy international law are point of reference in investor-state arbitration. And that poses specific research questions. That is, what makes the ICJ and PCIJ cited so often in all these different ways? What factors shape these references? What is the nature and quality of legal argument in ISDS, looking upon these external references, and what makes authority in adjudication, and what is the coherence between investment law internally and externally with public international law? My hypotheses are as follows. the ICJ, PCAJ references appear so often not that much for their, let's say, normative content as legal authorities, but as much as because of their prestige, which increase the legitimacy and the persuasiveness of the argument, and therefore the decision and ISDs as a whole. It's rather social capital borrowing or prestige borrowing than jurisprudential borrowing. And moreover, the reference to the court, even if they're posed as legal arguments, they appear to be rarely decisive of the outcome of the case. They appear at the margins of the main contentious issues and are not presented usually as driving for the reasoning of the tribunal. They turn to be rather a rhetorical ornaments. And as Sotirios noted on his analysis of the RCWA in his paper, the relevance and applicability of case law, including the ICJ jurisprudence, is usually not considered explicitly by the tribunals. And finally, references are used by particular actors for particular reasons. For example, very often is a respondent states, which use the ICJ references, perhaps trying to bring forth the public international paradigm, in the words of Antia Roberts, to the field where arbitrators may try to corroborate their reasoning with the well-known and seminal cases of international law, especially if they were ICJ judges. As we see in the table on the right, again by Charlotin, there is a slight correlation showing if you have an ICJ judge on the tribunal, you see more ICJ references, at least by the parties. Now let's talk about how I research that. I am running computational text analysis of publicly available dispute documents. I accessed them through Italo and gathered all dispute documents until the end of the year 2021. I gathered more than 800 investment cases, including more than 6,000 documents, being awards, decisions by tribunals, pleadings of the parties, submissions of the third parties, transcripts of hearings, and so on. Again, comprising around 7,000 files, because some documents have more language versions, while some documents have no files at all. They're usually in a PDF format. They are converted to text and subject to regular expression, in short, regex analysis. Regexes are, in short, rules determined search terms which allow identification of words in text. It's more a fancy version of a document search. And then I prepared search terms for the names of the court, its cases, its judges, registrars, statute, etc. in various language versions, which transfer into 577 search queries, meaning these regexes. Some terms are assigned the same search query, for example, aerial incident or Mavromatis, as they fit several cases of the court. Plus, I'm adding the document metadata for further analysis. And let me explain in detail with the example of the PCIJ's Oscar Chin case. By trial and error, I have found the best search query in the bottom row of the table, which includes both C and K, as sometimes may occur typos in the name, and 1N, removing a G in the end to remove false positives, like, for example, the word researching. An example, another of the false positive you see in the top row, which returned me with a term research in Newfoundland, which of course does not refer to the Oscar Chin case. Therefore, we have a return, there is no match. And the bottom row, again, we see the regex which gave me the most, 85 returns, and all of them were matching, giving exactly the name of the case, Oscar Chin, regarding the spaces or other signs between the letters, and also ignoring the size of these. These 85 matches transform into 52 genuine references. The main difference between the match and the reference is that, for example, in the main text, we have one return of the case, another one in the footnote, but of course they concern the same thing. Therefore, they are one reference instead. So having these 52 references, which have been made in 26 investment cases out of more than 800, which shows this case was not cited massively in investment arbitration compared to many other PCA decisions, for example, Factory of Chorzów, Lotus, or Mavromatis. Anyway, shows that this case appears in various contexts. And as we see, usually it is brought by the parties in their submissions, predominantly by the respondent. And very often these are brought as a, speaking broadly, legal authority. Therefore, having some indications that it should be authority the tribunal should take into account. Usually for the statement that the goodwill and the customers are a part of enterprise which should or should not be covered by the legal protection under the applicable law. Often we also see indirect mentions, that is another authority being a piece of scholarship or another case are brought, but it's explicitly mentioned that these authorities have relied or cited the Oscar Chin case. And as we see in the bottom right graph, the respondent was the one which the most usually brings this case, as it's argued that it's in favor of respondent, limiting either the jurisdiction of the tribunal or the substantive protection, either under the legitimate expectations or under the prohibition of expropriation. And even if the tribunal makes a reference in its decision, very often this is only in the part when it summarizes the positions of the parties or submissions of the third parties. Therefore, it's a strong.
Wojciech, I have to ask you to come to a conclusion.
Yes, and then just to conclude, with the numbers, I'm looking into the practice of legal argumentation of ISDS, the usage of particular authority of the ICJ-PCIJ, and revisit the concept of the so-called precedent investment arbitration. And I'm looking forward to your comments, questions, and the whole discussion. Thank you very much.
Thank you, Wojciech. Let me perhaps start with one comment and one question. The comment is that, as you correctly point out on one of your slides, the WTO appellate body, rightly or wrongly, has very seldom referred to the International Court of Justice. They have done it, but very, very seldom. And I say rightly or wrongly, perhaps it could and should have been done more often. My question probably reflects them, and I'm an old-fashioned legal academic. And whenever I see studies like yours that have a big data approach to legal research, I wonder about the limits of the conclusions that you can draw using that approach. But I'm sure you have thought very deeply about that before starting the research in that way.
Yes, indeed. So indeed, there are differences between the WTO and ISDS, which is by the nature of their sources and also the interpretive stance by these two different bodies. And that also would suggest that actually the usage of sources, external sources, is the issue of legitimacy. And we can notice different patterns between various international court tribunals, how they engage in a judicial dialogue with the ICJ. For example, the Tribunal of the Law of the Sea, in the beginning, it relied a lot on the ICJ. In the meantime, with maturing jurisprudence of its own, it limited that. WTO also perhaps considers itself self-reliant and also legitimate enough not to rely that much of external interpretations and external decisions of the other court. While in the ISDS, having ad hoc tribunals which decide disputes, having very broad, very general terms of a treaty, I think what we see in the paper of Sotiris and also what we see in Federico's presentation, they may be more keen to reach for different authorities. And of course, we cannot really look into the black box and really tell what was the reason for them to decide this way or another way, but decisions of tribunals are texts. And in this text, some things are cited, and we can assume that at least in some cases, this is somehow relevant. And very often the true story behind the citation may be, yeah, junior lawyer did the research and just needed to have some footnotes, so brought the case. But anyway, that the footnote is there and the argument is made can tell us something, at least on the superficial level of this textual analysis. So I think there is some usefulness to it. Of course, we cannot look into the minds of arbitrators, even if you just ask them. On the other hand, as we are lawyers and we base our work on the text, we can look for the patterns and denote maybe some additional and useful things, noting, for example, some personal preferences and approach and differences between, for example, different persons in the tribunal, differentiating between lawyers and, for example, professors.
Thank you very much for that. Next is Federico.
Okay. This is my timer, so I don't get off.
Well, I'll keep your time.
Well, I try to keep them on my own. Okay, what's my argument? My argument is that many investment treaty tribunals have interpreted and developed the concept of legitimate expectations that does not align with the way the concept has developed under domestic legal systems. So that's the argument. This is a sort of a long-standing research of mine, not because it's very particularly difficult, it's simply because I'm lazy and I can't find the time I used the CEO conference as a push for me to write. I did a little bit, but I have to do more. Now, the reason, a little bit the objective here is that the concept, legitimate expectation, the way it has been applied in investment treaty arbitration is perhaps the one argument as part of the fair and equal treatment standard, of course, that has been the most successful for foreign investors. And there's plenty of decisions that have awarded damages to the investor on that basis. And although expectations can be an expectation about everything, right? You could expect that the state does something or doesn't do something. It could be anything. That's the brilliant, actually, of the concept itself. The way in which it has been used in most cases by investors is to protect the regulatory stability of the home state, right? And this is sort of in the broader sense, in a broader setting. This has implications for the state ability to change and evolve and adopt new policies without paying compensation. Now, so the way I do it, I mean, a little bit easy way, but I focus on English law and European Union law. I mean, these are the two systems I know most. They're more familiar, but also they have certain features that are useful for purposes of this analysis. So basically, I compare the doctrine, the way it has been developed in domestic legal system, the selective legal system, and then compare it to the way that the doctrine has been applied elsewhere. Now, let me point to three aspects. There's probably plenty, but the three aspects I want to emphasize, let me see if I can go through that. The first one is the general scope. Now, many domestic legal systems use the doctrine only with regard to action of the administration. They do not extend, like English law, they do not extend to legislative conduct. Right? Some others do. EU system, for example, in principle, and German law as well, allows for a broader scope. Investment treaty tribunals, on the other hand, this is classic rules of attribution. Anything that the state does comes under the scope of the standard, the FET, and thus the doctrine of legitimate expectation. Doesn't matter whether it's the administrative authority of the province of Florence or a legislative act enacted by the parliament, or a judicial court, constitutional, anything goes under. The second issue about the scope is the kind of protection given. I would say that, at least in the sort of English world or English influence world, most systems only afford procedural kind of protection. You have an expectation. Is it a legitimate expectation? Yes. You will not get that expectation. The only thing that you'll get is a duty for the administration to hear your views before they frustrate that expectation. That's it. Procedural guarantees. This was the English system up until 20 years ago when it changed. And this is the system that applies in many other countries. Only procedural. You don't get the benefit. You get to be heard. Has anybody here in the room has ever heard that discussion in investment treaty arbitration? No. They jump straight into the substantive protection. I mean, that's just the start, right? Just to give you the different scope. Now, there's actually a third aspect, which I'm still working on. I couldn't find in English law any case where the protection of legitimate expectation has been used to enforce an expectation that comes out of a contractual arrangement. I can't find it. And I think the explanation there is because the concept of legitimate expectation is there to protect what is not already protected by law. So a contractual commitment, the contractual undertaking, a contractual promise is protected under a different set of rules not the doctrine of expectations as a judicial review mechanism for the conduct of public authority. You read most tribunals, treaties, there's no difference. In fact, the emphasis is often on, but there is an investment contract, there's an undertaking. That's legitimate expectation established. Okay, let me move to the second point. See, time is running out already. The second point is more difficult. And the question is there a legitimate expectation? Right? And this is where tribunals and parties litigate at end. There's a tendency in investment treaty tribunals to do a massive mistake. So in domestic law, what is required is an assurance, a promise, an undertaking by the public authority. It can be expressed, that's the paradigmatic case, an express promise. Could be oral, could be written in an email, it could be anything, a report, a guideline. It could also be implied, right? But no matter what, there has to be a promise, there has to be a representation by the public authority. And that has to be specific and clear and unconditional. This is where most claims under domestic law lose. They can't. It's never clear. There's always another statement by maybe the same authority or another authority that sort of qualifies it, makes it conditional. You cannot. Investment treaty tribunals often skip this passage. There is a legislation there. There are certain policies undertaken, and on that basis, you create the legitimate expectation. I read, and I use my last 20 seconds, a case which I only discovered this morning. I think it's the first case that Columbia lost, the Glencore, 2019. Legal expectations, the tribunal says, can also be created in some cases by the state's general legislative and regulatory framework. An investor may make an investment in reasonable reliance upon the stability of that framework, so that in certain circumstances, the reform of that framework may breach the investor's legitimate expectation. And this is the trick, which clearly is disaligning with the whole concept. There has to be a promise, clear, precise, and unconditional, which may stem from a conduct. It may be implied, but when it's implied, it has to really be exactly clear. And often the fact that there is a regulatory framework, the focus then switch on the expectation of the investor, and that makes it legitimate for the investor to expect that framework won't change, without any reference to this assurance by the host state that has to be there. The third element, I don't say, this is the thing I sort of done in the past, which is in fact the most horrible, because it transformed the nature, but maybe we can pick it up later.
Thank you very much. You speak about it with such passion that I'm wondering, what is the most pressing concern or concerns that arise as a result of the failures of investment tribunals to align the doctrine of legitimate expectation with what we see at the domestic level? What is your?
Well, there's so many, but and I conclude with the third point, so I can answer your question. The third massive failure of investment tribunals, many, not all, because this is also difficult to speak because some actually do it properly, but it's a minority. Domestic courts, right, when they apply legitimate expectation, even in those cases rare that they find a legitimate expectation, they then ask the question, what kind of protection do they get? Actually, should the legitimate expectation get the protection? And that's where the question revolves around, is there a policy rationale that overrides that legitimate expectation. And if the court thinks that there is one, the legitimate expectation is dispensed with. Well, sorry, but there are greater interests. So this is why, and this is 2005, organized a seminar in London on legitimate expectation. It was interesting. We all looked at different aspects. Soren Sorensen, who had written a PhD and a book on legitimate expectation in French, English, and European law, said something which was sort of, in those days, was quite interesting. He said, I looked at all the cases in those three jurisdictions, and I can point the successful cases on the fingers of one hand. Now, if you do the same with investment treaty arbitration, you'll probably need more than one hand. The concern is this, that this interpretation by most investment tribunals has transformed the nature of FET from a rule or a principle that focuses on the reasonableness of the conduct of the host state, or unreasonableness, depends, has transformed it in one that guarantees many things, but particularly regulatory stability, without considering the merits of the reason why the state has frustrated expectation. And that, I think, goes against the origin and, I think, purpose of FET.
Thank you very much. Ernest, you're next.
Thank you, Peter, and hello, everyone. As Peter indicated, I will be talking about the ISDS in the context of the Ukraine-Russia warfare / lawfare. I think you're all quite familiar with the warfare itself, but also lawfare. I know most of you are actually working on the subject from different aspects, especially after the 2022 invasion. It's picked up a lot of interest in research, legal research. And of course, as is obvious to most of you, there are many fronts in this lawfare. The ICJ front, the 2017 case in the aftermath of the Crimean invasion, the more recent 2022 case, the numerous, I think 10 now, ECTHR cases, plus the individual applications at the ECTHR. There is the more recent ICC arrest warrants for President Putin. We have the more, again, recent Ukrainian initiative to start a claims commission for the damages. So there are quite a few fronts going on. These are one side of this lawfare. Of course, there are things that Russia is doing as well, such as passing domestic laws and threatening expropriation to these companies who may exit the Russian market. This is just one example, and also the sort of imposition of the Russian ruble on the transactions, etc. This is the general sort of public international law research tendency to focus on these items that I've mentioned, especially in the, for example, in ICJ and ECTHR context, we have an upsurge in the third-party participation, which is unprecedented in both of these courts, maybe less so in ECTHR, but definitely in ICJ. So most of the attention, most of the spotlight has gone into these areas. One aspect of this lawfare that is explored to some extent, but not so much, is the ISDS front. I'm not sure why that is. Perhaps, again, it's a bit of a taboo to talk about ISDS as a legitimate avenue to seek justice. This might be the reason, but the reality is ISDS is being very actively used in this lawfare, primarily by Ukrainian investors against Russia, but there are also Russian investors against Ukraine, which is even less known. So what we try to do in this paper with my co-author, Erman, who couldn't be here, is to first highlight this front in the lawfare by emphasizing that ISDS is indeed not only a part and parcel of this lawfare, but actually probably one of the most prominent aspects of this lawfare, one of the most understated. It is also, our claim goes a bit further than that, that it is also a contrary to the foundational myths that ISDS has, it is also a very highly politicized front in this lawfare. And for those familiar with investment law will know that it's in the context of ICSID back in the day in '86, the then Secretary General Shihata had this very famous paper basically saying that ISDS is a depoliticized dispute settlement method. It's actually apt that we're in Colombia because the example that he was using was the Latin American experience with ISDS. But his chief argument, and I'm oversimplifying it, is that by removing the involvement of the home state and sort of putting the investor in the claimant's table, we are in a way depoliticizing these disputes. We are preventing the escalation of this dispute into a political fight. And also in the context of Latin America, we are also preventing the diplomatic protection to extend and sort of bother the Latin American countries because they have suffered so much in gunboat diplomacy and sort of prevention of harassment, so to speak. So this is and the way we do this, the way we sort of argue in this way, that's saying that investment state dispute settlement is actually a quite politicized method of settling these disputes, is very prevalent in these macro political conflicts that are interstate, because the presumption here is that there is an overarching macro political crisis, the war between Ukraine and Russia, and this context actually spills over to these ISDS claims. So the very formalistic way of reading the politicization, the removal of the state as a disputing party in this context, doesn't really do much in the way of depoliticizing these disputes. Removing, for example, Ukraine as a home state, as a home state, doesn't really do much. And we are sort of experimenting with a dichotomy here. Sort of, we attempt to divide these investment disputes into two, roughly. And again, this is I'm simplifying here, but one of them is the ISDS disputes, where the surrounding context, the violation, the alleged violation, is quite anecdotal. It's very specific. One example is, for example, Methanex. California bans a substance, Methanex makes a claim, Canada doesn't get involved. And there is a certain value in claiming that there's a certain depoliticization by not bringing Canada and US against one another. We call these disputes the isolated cases because they are very anecdotal, or their sort of radius of impact is very limited vis-a-vis the overarching political context. The other group that we refer to as a collective disputes refers to disputes that stem from bigger macro political, usually interstate crises that have a transboundary cross-border spillover effect. And I think Ukraine-Russia war is a good example of that. Other examples could be the Libyan civil war, the Syrian civil war, that produced a lot of ISDS cases. In the latter type of disputes, the argument is that ISDS is actually, and I'm perhaps being devil's advocate here, but ISDS is actually, compared to the other interstate venues, it is politicized and it is potentially effective. The enforcement is always a problem. This is a given, but the use of the current trend in the use of ISDS as a way to sort of claim compensation, to try to get some justice out of this situation is quite noteworthy. This situation is even further complicated by the involvement of SOEs, Ukrainian SOEs, that are bringing claims against Russia. And I will stop here because this is a subject that can be elaborated a bit more, I think, in the Q&A. Thank you.
I have a question on depoliticization. I'm slipping over the word. Isn't any dispute, international dispute, that is referred to binding adjudication, isn't that dispute being depoliticized? Yeah, I mean, if I look at the WTO dispute settlement, which is the only dispute settlement system I'm familiar with, If I look at that, the great virtue is that you take it away from a political clash and you put it into a legal process, at least for some time. And then there will be a ruling on the law. So if you agree with that, is it so problematic that you see that investor-state dispute settlement sometimes also is in reality an investor, but behind the investor really a state? Is the difference that big between the?
No, it isn't. And what a politicized dispute is, the definition of politicized is so big that also we can even argue, I think this also goes to what you were saying, that the moment we sort of judicialize a dispute and take it to the ICJ, it is, compared to what it would be without that judicialization, would be by definition depoliticized. I fully agree with you. But this, in the context of ICSID in the 80s, the argument was the availability of this direct remedy to the investor versus the state, thereby eliminating any, or at least the diplomatic involvement of the host state, would go some way to depoliticizing. And one can, again, it's not clear in Shihata's contribution, and again, in the depoliticization scholarship, every paper adopts a slightly different definition of what depoliticization means. But one can also argue, based on what he has written, maybe wrongly, but if there wouldn't be an investor-state dispute, and if there was an interstate investment dispute, compared to that investor-state dispute, that would be relatively more politicized. So there are different ways of politicizing, in that sense that it can be diplomatic protection, which is, yes, it is a sense, in a sense, it's a different shade of politicization. And when we're looking at ISDS, relatively interstate dispute settlement might be political. There is no clear answer to that.
But I get your point.
So yeah, I mean, it's possible, and I only have like less than 8 minutes. I would love to elaborate on this, but you know, this there are also different angles to depoliticization. Diplomatic protection is one. There's a brilliant paper by Geoffrey Gertz, I think, where he argues that US, despite all the attempts to sort of remove it as the sort of home state being involved, diplomatic protection, they still are quite very much involved through some backdoor as the home state, of course. And I guess when a foreign investor is frustrated in a foreign country, the first thing they will do is to go to the embassy.
You make your point very clear. No, Caroline, last but certainly not least.
Thank you. So I was invited to join this panel at 10 o'clock last night, and because it was otherwise going to be a manel. So I'm very happy. Well, there was some assumption that I identified as female made on the part of Marcus. But anyway, I'm going to talk about something that I've already talked about a lot of times. So apologies if you've heard me talk about this before. I do think about different things, but I'm going to talk about exceptions yet again and offer a theory about how they should be interpreted, which most of you will probably disagree with. So what do I mean by exceptions? I'm actually taking quite a broad approach, probably broader than your average investment or trade lawyer would understand exceptions. When I'm talking about the relationship between rules and exceptions, I'm talking at a basic level about the interrelationship between two norms. So the first norm prescribes a general rule, and another norm exempts or excludes specific circumstances from the scope of the rule. So I'm getting ahead of myself. So in other words, one norm is in the form of a command to governments, such as you must afford fair and equitable treatment, or you must not discriminate. And the other norm takes the form of a derogation from that command in specific circumstances, such as you are not precluded from adopting non-discriminatory measures to protect public health, or this agreement does not apply to prudential measures. So that's kind of the structure. And I think there are several different types of investment treaty provisions that fall within this structure. There are, of course, general and security exceptions, carve-outs and reservations. I'm going to get more controversial as I go on. Scheduled non-conforming measures, in certain circumstances, denial of benefits provisions, such as the CPTPP provision on tobacco control, And then finally, although most people will probably disagree with me, I think that police powers annexes and investment treaties are also exceptions. They say typically that except in rare circumstances, non-discriminatory regulatory actions designed and applied to protect public welfare objectives do not constitute indirect expropriations. Now, why am I taking such a broad view of the exception? Well, I think all of these types of provisions seem to follow the same structure in terms of being a relationship between a command and a derogation. And I also think that they have the same, what I would term, analytic character or legal character. And I'll talk about the two different interpretations that you could give to exceptions. And I take the view that I think is uncommon, that we should interpret all of these exceptions in the same way. So the first way to interpret them is to say that when the exception applies, the treaty obligations do not apply at all. In other words, the treaty rules apply unless the state is taking action in conformity with the exception. And here we might say, well, the exception is not really an exception at all. It's actually a narrowing of the scope of the rule, or rather a permission to do something. The other option is to characterize the exception as an affirmative defense, which is how the general exceptions are approached in WTO law. Here, the state relying on the exception doesn't deny that they failed to comply with their treaty obligations, but they seek to avoid the consequences of that prima facie breach on the basis that the state is acting to protect certain interests that the treaty parties have agreed should be overriding considerations. Now, there are several reasons why this distinction is important, and I will speak to at least one of these depending on the time that I have. So the first reason that this distinction is important is that the character of the exception actually gives rise to some quite potent normative considerations. Laws can have a potent symbolic function. As Hart observed, a permission is intuitively something quite different to a defense. Governments, not to mention civil society, if we're thinking about the legitimacy of the regime, attach symbolic significance to the question of whether the relevant conduct is lawful and outside the scope of the obligation, or provisionally unlawful but justifiable, and therefore ultimately not in breach. And so if we unpack this a little bit more, we can see that there's a distinction between conceptualizing the regime as one that defaults to a so-called right to regulate, and I hate that language, unless the conduct is specifically prescribed, or as a regime that generally prohibits government action affecting foreign investment unless that action is expressly permitted in exceptional circumstances. And so I think this issue has quite an important signaling function. Now, even though if we treat the exception as a defense, even though a prima facie breach is defensible, characterizing the exception as a defense in effect says that the protection of foreign investment is the most important thing, and you may only regulate to protect the environment in exceptional cases and not in the ordinary course of governance. How am I going for time?
You have 3 minutes left.
Okay, great. I'm going to say one more thing. Another point is that the way we characterize exceptions may bear on the way in which the substantive treaty obligations are treated. So if exceptions are defenses, this signals to tribunals that the purpose of the measure should only be considered in the context of determining whether the exception applies. And this is exactly what happened with the WTO. I'm trading into controversial territory here, but the appellate body has said that the general exceptions are defences, and as such, it will not examine the purpose of a challenged measure in the context of the primary obligations, even where the rules of treaty interpretation would probably have permitted that. I'm talking about aims and effects here. So in investment law, because most treaties don't have general exceptions or security exceptions, or at least there aren't all that many cases involving any type of exception at the moment. Was it something I said? So investment tribunals, they take into account, oh, see you. They take into account the state's reasons for its actions when determining breach, which is desirable in my view. So as Robert Hudak noted in the WTO context, considering regulatory purpose at the point of obligation avoids what he said was the excessively rigorous treatment given to claims of regulatory justification under Article 20. I feel like I should probably leave it there. So thank you for the opportunity to disseminate my propaganda at the last minute. I really appreciate it.
Thank you very much. Let me assure you, first of all, that the two walkouts have nothing to do with you, but probably with the arrival of President Samper.
For your presentation.
I have two questions for you, if I may. It's unfair because I mean, I asked one question to the others, but nevertheless, would it be useful to do what they do in WTO law, to make a clear distinction, a terminological distinction between exemptions and exceptions? I mean, I heard you define exceptions in two ways. One way, the first way in which you used it, we would refer to them as exemptions. And I think this is, but yeah, every discipline has its own terminological way of approaching things. But this might be a useful, it's more a comment than a question, but you may disagree. And then the real question to you is you made the observation that there are many investment treaties, especially the somewhat older one, I think, that do not have exception provisions. Should they have exception provisions?
Yeah. Okay, thank you. So, yeah, so I must admit I'm not super familiar with exemptions in WTO law. In investment law, they're usually known as carve-outs. And so some people would say, well, a carve-out or an exemption is a permission, according to my terminology, whereas an exception is a defense. But I say they're all permissions. None of them are defenses, so none of them should be. But this kind of leads to your second question, which is, well, should investment treaties contain exceptions? Well, governments have increasingly decided to include exceptions in investment treaties because they're concerned that investment tribunals have unduly trampled on regulatory autonomy. But I think, and I'm not the only person to say this, but by including exceptions in investment treaties, governments might paradoxically risk undermining regulatory autonomy even further. Because exceptions, and this is where they're treated as defenses. This is kind of highlighting the problem of exception as defense, because exceptions specify a closed list of permissible objectives. They also specify often a necessity test, which is actually a more stringent test than we see tribunals applying in the context of the primary obligations. They're an equitable treatment. They usually apply a rational connection type test. So just to conclude on my response, if that's okay. So I think really what we should be doing in investment treaty reform, if we want to maintain the regime, which is a separate paper, if the substantive obligations were more precisely drafted, so we know what conduct exactly is and isn't permissible, then maybe we don't have any need for exceptions at all. So if you look at CETA's fair and equitable treatment provision, for example, it says that you can only breach fair and equitable treatment by manifest arbitrariness, targeted discrimination, and so on. And the intention of the drafters there was to exclude regulatory measures from the obligation itself. So I think at the very least, states should be very careful with their drafting of these provisions. Maybe they should say that they are permissions, for example, by saying that the obligations do not apply to measures necessary to protect the environment and so on. Even then though, if you look through the cases, carve-outs have been treated as defenses by some investment tribunals. So it seems to be a really hard thing to do to get the wording right, because I mean, maybe states should also say in their treaties that the intention of the exception is to avert liability, to avoid the eco-aura situation, which we all know about. So I'm not convinced that we should have exceptions in investment treaties, but I'm very interested in what other people say about that question. So thank you, Peter.
Especially on that point, I suppose. The original idea was that the panelists would now have an opportunity to comment on each other, but we have 20 minutes left. And I'd rather hear from the audience. And in answering the questions of the audience, if you really need to say something about what your colleagues have said, then you're free to do so. Let's start at the first row, madam. No, that's you.
I'm very surprised because I haven't managed to have a question.
Oh, sorry, I thought you were waving your hand.
The first time she gets the chance to ask a question.
Please.
Okay,
Sorry.
it's actually a common question to, it's two questions, but interrelated to both Caroline and Federico, and it has to do with the distinction between the primary rule and the defense or exception or permission. So Caroline already knows that I disagree with this classification, but I definitely see the point. But my argument, or rather my comment on this is, isn't the existence of the necessity test actually what differentiates a carve-out from an exception? Because the necessity test essentially, first of all, signifies that something that may qualify for an exception today may not qualify for the exception tomorrow, which is very different from interpretation of a primary obligation. And secondly, it presupposes a finding with respect to the primary norm, because we can't really know the parameters of the internationally wrongful act essentially for the application of the necessity test if we don't have this prima facie bridge. And on the symbolic value, I'm also wondering, which is where I think that this intersects with Federico's presentation, why are we trying to normalize the exception in a way? So why are we trying to fit all these different things within the primary rule? What is actually the symbolic value of this? Isn't it better to just tell states, this is the obligation? And these are the circumstances under which the obligation will be set aside, in a sense, in order for you to serve other more important issues. So why are we trying to reinterpret legitimate expectations, for example, to fit in regulatory distinctions or fair and equitable treatment more generally, as Caroline suggested also yesterday in her presentation, and we don't just stick with prima facie inconsistency, but justified. That's, sorry.
Caroline, I think you were the first person addressed.
Okay, thank you for your question. I'm not too sure I can answer it in the time I have available, but I think you make one important,
Interesting point. That's maybe the terminology of necessity, or sorry, necessary, not wanting to confuse the two concepts, suggests that it intends to operate its defense. But if you look at the different provisions in investment treaties, we see the related to, which is the WTO kind of model. We also see some exceptions using the term for. So actually the nexus can be quite weak and can really only be a rational connection. So I'm not too sure that the use of the term necessary designates it as an exception. But it kind of goes back to the ordinary meaning. And I don't think the ordinary meaning of exceptions actually does shed any light on their analytic character. And if we look at the object and purpose of at least the more recent investment treaties, we see references to prosperity, sustainable development, health, and so on, which seems to suggest that I think it gives weight to the argument that these are permissions. And also when you look at the treaty more broadly, which has got all these kind of affirmations of states' rights to regulate and so on. So I think treaty interpretation doesn't really help, but helps a little bit with my argument. I've got some things to say about your paper.
I'm sure you do.
Maybe we can do it later.
Sure. I want to hear more of the people, but I didn't really get. Do you prefer to separate the two? So I have an obligation and exception. Then we disagree very much.
Because I thought you were suggesting that through legitimate expectations, we wouldn't really have to go for that if we were to accommodate regulatory distinctions within fair and equitable treatment instead.
Yes, that's what I said, but it's part of the obligation, not as two distinct features.
Okay.
Please go ahead.
Yes,
Yeah.
one quick question, Federico. Would your conclusion be any different in a situation in which there was a stabilization clause in the underlying contract, and we say there is an umbrella clause in the treaty, and would the investor be entitled
So it's a decision clause in.
in the underlying contract? Yes.
If follow my suggestion is that the concept of legitimate expectation should not be used to enforce a stabilization. Any contract. That doesn't mean that the treaty will not protect the contract. Right? Now, there's an umbrella clause often in 45% of the cases. Well, the treaties maybe less should do that. I mean, I think there are other ways in which you can use even equity as a way to protect a certain arbitrary and unreasonable conduct of the state vis-a-vis the way the state has behaved as a contractual party. But it's, in my view, it shouldn't really be, I mean, it's actually, what do I know? But I'm using this comparative benchmark as my link. And we can decide that, forget that, you know, international law does it differently. We want to provide more protection, and so we'll do that. I think, you know, there's an initial question of, you know, where does this concept comes from, right? It's in no treaties, well, except the last few ones. And so the most plausible is, you know, general principles. I suspect that's, you know, although it's not much debated. In the same case brought against Colombia, the Colombia defense, and it's actually quite exceptional that they do this. Maybe it was internal lawyers, which in fact we heard speaking two days ago at the conference. They argue that FET does not include the protection of legitimate expectation. And the tribunal took one sentence and said, there's 150 different tribunals that said it does so, including a few scholars. So disappeared. But so there's a question of, you know, how does even this concept comes into, and I take the point of view that it's already there. Let's actually apply properly. And this is why the connection with domestic law, because I think it's the only really legitimate authority that we have. There's nothing else. Even the International Court of Justice doesn't seem very much inclined to recognize it as a principle, even part of FET. But that's future development.
Okay, second, still on the first row, gentlemen.
I had several questions. I don't want to monopolize, so I'm going to ask only one for Gunis, who hasn't gotten a question yet. I found your paper very stimulating. By the way, I should say Daniel Franchini, University of Sheffield. What you said about ISDS is in the second category of cases you have said that it's both politicized and effective. My question is, effective for what? Because they're very effective to do one thing, which is providing compensation. And isn't there a risk when we ascribe this idea of politicization that we see, especially when it's not state to state? The great majority of the cases that I think you cited as well are investor state. Is there a risk to see some sort of design, coherent political design that is not there? And I just leave it at that.
I specifically had in mind what happens after the award is rendered, because the eventual outcome of the ICJ cases, the ECTHR cases, assuming there will be a claims commission, the question of funding and whether or not seizing of assets will be possible, all that stuff. Without Russia's consent, that's the important part. I think there are a lot of very important issues about compliance in other forms of this lawfare. Right? This is not to say that ISDS is a smooth sail, especially if you're talking about Russia. You know, we literally have only one case where Russia paid, and that was the Saga, the Sedlmayr case. I'm not saying effective relative. I mean, potentially, perhaps. At least there is a prescribed way of enforcing it. Maybe you're going to give Russia a headache for a while through your convention, it's sort of chasing Russian assets in several countries. But when you actually look at the totality of the different fronts of this lawfare, if anything will yield any sort of pecuniary outcome, at least, that is unfortunately ISDS.
Very well. I will give now priority to questions to Sotirios and Wojciech, if there are any, but perhaps their presentations were so clear and uncontroversial that there are no questions. So are there any questions to either of them? Andreas.
Thank you. Just on the references, you know, this is fascinating in a way because it sort of shows sort of a bit the conversation between courts. But what I find is a sort of the bigger question in there that I'm not really yet seeing is the qualitative difference in the references. So you may well have a reference that is just sort of there as a matter of course and is always there when we refer to that one principle, and it just happens to be carried over into the next case and the next case and the next case. And then you may have a case where you actually engage on the substance with something that's been said by another tribunal. Either you distinguish that, or you disagree with it, or you somehow draw some inspiration. So I wonder to what extent in sort of, you know, the analysis that you've presented can be supplemented, or whether there's sort of an additional step that could have sort of grasped that, you know, that difference. Thank you.
Very clear. Wojciech?
Andreas, thank you very much for this question. I fully agree. It's a very big thing. And this is the thing I'm taking into consideration because, of course, between the very bird's eye view on the quantitative aspect of the mentioned citations, it requires a lot of manual work and coding. And of course, you cannot fully just code binary if it's a matter of course citation or have actual engagement. But of course, with close reading, you can really see whether the tribunal or another party engages with the legal argument. And as far as possible, I'm doing it. For example, in the Oscar Chin case, 5 of the 7 claimants' mentions of the case actually are responses to respondent arguing that the case is not really applicable, or for example, it's not really proving the point respondent's making. So therefore, we can assess, and that's a part and parcel of the project to really see how really we have this actual engagement with the case. But very often, actually, we have a matter of fact, as you mentioned, mentions of the case in a string of several cases, ICJ cases mixed with investment arbitration cases, without usually any context. I suppose Barcelona Traction case is a great example, when very often respondents try to use that passes from the ICJ on the shareholders having standing or not, against the treaty language, which is usually very explicit, and it's a established practice in investment arbitration that shareholders usually under BATs have standing. Nevertheless, respondents with Argentina tries to go on with Barcelona Traction reference. So we can see sometimes how or it is engaged or not. So thank you for this point, and I would like to really pursue this project. Yes.
Very clear. We do have a question for Sotirios. Yeah,
Thanks. So Lauren Bartels from Cambridge. I detected a criticism in what you were saying in terms of how investment tribunals deal with unilateral declarations. Of course, it's well known that the ICJ has said that they are not to be interpreted as treaties. They are to be interpreted with far more deference to what was intended by the state. But I wonder whether that's just, you know, one point on which tribunals are a little bit basic when it comes to interpreting international law. The Vienna Convention is not always applicable. What would you make, for instance, of internationalized contracts which can be subjected to international law? For instance, in more recently than in the 70s, the Occidental Ecuador case in England, What's a tribunal to do?
Well, as I said, I focus on these particular three instances of interpretation. As to the criticism that you said, yes, there is a criticism there, and it stems from specific cases. For instance, yes, for instance, in the Spanish saga case with relating to subsidies to renewable energy, for instance, a royal decree awarding subsidies for the renewable energy sector, and which is equally applicable to domestic investors and international investors, to be called a unilateral act on the international level in a footnote. As you said, it contrasts the very cautious approach that the ICJ actually has laid down with respect to the identification of whether something, an utterance, an act is binding on international law or not. Now, with respect to internationalized contracts, first of all, I have to say that this is not part of the examination. And obviously, this largely relates, I guess, to whether these internationalized contracts actually should be interpreted under international rules or under domestic law. And this is actually, and let me go back to the unilateral acts, because with respect to unilateral acts, there is also this debate. Where does this fit? Okay, and I guess the domestic law fits into the idea of, on which plane this thing is binding, right? Once you have decided that this is binding on the international plane, well, obviously, domestic law does not have a lot of role to play. But this determination is something that is subject to rules of international law that accord deference to the act, and actually there is no presumption that this is binding on the international plane immediately.
Thank you very much. I open the floor again for questions, please.
Thank you. Tony Madison, Ottawa. I had a question for Carolyn. I want to follow up on your way to speak down, and I think about the challenge of drafting exceptions effectively to ensure that they are characterized as permissions. And the Echo Oro case is the most obvious example of a tribunal that found that the drafting wasn't sufficiently clear in that regard, but I think they were wrong, but that's what they decided. As you may know, subsequently, Canada has revised its model investment treaty and has actually taken out the general exceptions, which is kind of extraordinary in a way because Canada was a bit of a pioneer in including them in the first place, but they've replaced it with what they're calling a right to regulate provision, and I just wonder, and I think we're probably likely to see a few more of those in treaties subsequently. I just wonder how you would characterize that in terms of your approach to exceptions. Is that an exception or is it some other kind of hybrid thing, and what should be its impact in the treaty?
I'm not an exception. I think it's a kind of an interpretive declaration, saying that as a starting point, we think the governments ought to be able to regulate to promote public welfare, or whatever the terminology is. And it's meant to influence tribunals in their interpretation of the substantive obligations. It's meant to kind of infuse through the whole treaty. I can't recall off the top of my head which treaties these are in, but you do see some treaties with clauses that say nothing in this treaty is meant to prevent states from regulating in a manner otherwise consistent with this agreement. And I just think those are completely useless. I don't see the point at all.
And the TRIPS agreement.
Right.
Is that sort
Yeah. But I was actually looking at the Canada model today, and I noticed that although it doesn't contain general exceptions, it has a lot of other types of exceptions. So it's got carve-outs. There's a denial of benefits clause in relation to international peace and security, which is a type of exception. So it is still including exceptions in my view. I'm very interested to know why it did away with general exceptions. I haven't been able to find out. Maybe, do you know?
I don't know. I do know that locally in Canada, people who work in investment, it's been significantly criticized by colleague Wolfgang Oster.
Yes.
Critically. I think it's might have done better to try to redraft the acceptance in somewhat of the manner you described, rather than giving up on both.
There are about 7 pending cases at the moment involving general exceptions. So it'd be very interesting to see what happens after ECO or.
Very, very briefly.
It's the EU approach. So, which is the fact reflected, I think, in CETA. There is a general exception, but only applies to the liberalization commitments. So national treatment, MFN, not to the standards, expropriation, NPT. And it makes perfect sense because those are the standards that you don't want to have a second step. You want to have that analysis right there inside. And particularly expropriation, because it's in the annex, right? So imagine, in fact, this is the problem that's already created with the Canada-Peru FTA, where you have to basically an exception under the expropriation, the annex, and then you have to apply the exception again at the end. Totally confusing. I think, from my perspective, I've always argued that that's the right approach.
Thank you very, very much. Time is up, and unfortunately, we're at a very tight schedule, but please join me in thanking this panel.
Now you have fair tweet, right? That he ignores the end.
Well, that's what
Goes back to the general exceptions anyway. and says There is no carve out.
That decision is completely bizarre.
It's.
I'm writing something about it.
I'm like, if they can be arbitrators, I can.
But would you ever be? Would you ever do?
No, I would never put a signature under the decision.
No,
You mean I arbitrate?
Would you ever service an arbitration?
I mean, that really depends on the case.
Thank you very much. Have a great afternoon. Enjoy Bogota.
Goodbye.
See you soon. Goodbye.
See you soon.
Yeah, well, it's